This morning on the Ag Issues program, as he does every couple of weeks, we are joined now by Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine. Good to be with you.
Yeah, and the reason why we're on the phone, by the way, is you've got a big tax seminar. You're in Pennsylvania right now?
Lancaster, Pennsylvania, in the midst of the Amish country. Very beautiful part of the country, and I'm glad to have my wife and our daughter with us and two of our grandchildren on this trip, and been able to see some things in Philadelphia, some historic things before the meeting, and they're getting to enjoy the countryside while I'm talking the next 2 days.
All right. Well, let's get to it as far as what we're going to be talking about. And by the way, what we're going to discuss today on your edition of the Rural Practice Digest, this is going to be on your Substack, or it is on your Substack already as well. But it's going back to the One Big Beautiful Bill Act that takes place. But we're going to focus in on a couple of things that are going to be in the Act, or a couple. There are a lot of them we can talk about. But one of them is Supplemental Disaster Relief Program. And, of course, that was established under the American Rescue Plan Act of 2025. Yeah,
you mentioned my Substack. My lead article is on the commodity title, and you and I have discussed that a little bit on previous program, but deep into the issue, several pages in, I get into this, the SDRP, the Supplemental Disaster Relief Program, because I'm getting a lot of questions on that. So I wrote up a couple of pages, actually about 3 pages in my digest on this. And this came in, as you said, by virtue of the American Rescue Plan Act of 2025, and it's providing financial relief to producers who experienced significant production quality or revenue losses during 23 or 24. So this is not current. This is going back and picking up the prior 2 years. And this is, you got to qualify for this, and this is for the government's fiscal year that ends September 30th of this year. So FSA is administering this in 2 stages. We know what the rules are for stage 1, and I would anticipate by mid-September we're going to know what the stage 2 rules are going to be and what stage 2 is going to cover. So what we need to go through are who's eligible for this and what does it cover in terms of losses, and then how are the payments calculated. I think that's the key points for us to discuss, Greg.
Well, let's get into that because, like you said, the most important thing is you have to be eligible to be able to receive some of these funds.
Yeah, you have to be a crop, tree, bush, or vine producer. So, of course, in Kansas, we're concerned about crop producers that had losses in 23 or 24. You also must have received crop insurance or NAP indemnity for a qualifying disaster. So those are going to be your 2 primary requirements. Now, when they do come up, this is stage 1. When they do get to stage 2, those that are going to be eligible are those that experience losses not covered by insurance. But what we're talking about in stage 1 would be your insurance-covered losses, or if you had a NAP indemnity for a qualifying disaster. And you're going to have to fill out some forms. Of course, this is FSA, so you're going to have to fill out the forms and comply with conservation provisions. And your forms are going to be the 526, the 901, 902, the AD 2047. And one other thing to keep in mind when we get to the calculation of how these payments are actually computed, replanting payments are going to be excluded from the SDRP calculations. So the covered losses have to result from specific natural adverse weather events during 23 or 24. So that's going to be your wildfires, floods, tornadoes or derechos, the straight line winds, excessive heat, smoke exposure, winter storms, freezes, drought, those types of things. So if you had that in either 23 or 24, then you want to start to look to see whether SDRP, for your covered losses, again, insurance-covered losses, or you had a NAP indemnity, whether you're entitled now to any payment in stage 1.
And, a couple of things that are to look at. One is the maximum payment cap, which is a big one in that, but also determining the eligible indemnity, too.
Yeah, that's right. The stage one payments are tiered. So you've got a 35% payment factor that's applied to a total calculated loss. Now, your payment, as you said, cannot exceed 90% of the loss. So whatever your loss is, 90% of that, and then we're going to take a fraction of that. And then we might get into stage two. So what you want to start with, if somebody's is listening and has a pencil, and then you can subscribe to my Substack and see the details on this. But what you want to start with is, what was your total indemnity paid by crop insurance or NAP? Now, back out any replant payments that you received. You can't count those. So start with what you got from crop insurance or NAP. Then you apply that 35% factor. So the payment factor, again, is 35% of your calculated loss. And that's designed so that they make sure they've got enough funds to equitably distribute these across all eligible producers. Then you apply the cap, and the payment cap cannot exceed 90% of the total calculated loss for producers that had insurance coverage of at least 80%. So, and if they had less than 80%, then the cap is 75% of the loss. So you have two potential caps depending upon the level of your insurance coverage. And then there might be an offset that has to apply, because if you've got payments from other USDA disaster programs, maybe you've got an ERP payment, you back that out. That's offset to prevent duplication. So those are the basic 4 steps in terms of calculating your payment. And I go through in my article, I put some numbers on this. I come up with a hypothetical farmer and certain losses on a corn crop for 2023 and show you how this would work.
Let me ask then, for stage 2, like you said, the sign-up coming probably in mid-September. You expect any tweaking or big tweaking of the numbers as far as where this is going to go as compared to stage 1?
That's a good question. I think it probably depends, and it depends on funds. If they have enough funds and if they've staged this out appropriately, then they probably won't change anything. But they could pare it down, perhaps. It depends on how many people apply for relief and how many will qualify. And that's always, when they get into these types of programs, that's always something that's kind of an unknown until they're into it. But they are trying to make sure that they have enough funds for stage 2. So that's why you have these factors that get applied and cut down what your loss might be in terms of what your reimbursement. So, for example, what I showed in my Substack was I showed a producer that had 85% coverage level on crop insurance and got an indemnity payment of $100,000 and a replant of $5,000, which you can't include, but then they suffered drought. And I came up with, once you applied all the factors, a $33,250 payment under the SDRP. So it's not chump change, but it depends on how well they've done their projections to know whether they're going to tweak any of this, and then what the rules are going to be for stage 2.
And just a reminder once again, because it's needed, this is for qualifying disasters, related to qualifying disasters, and not necessarily because of the commodity prices that have dropped.
Yeah, this is not tied to commodity prices. This is on, well, kind of, I guess indirectly it might be, but this is tied to having had a qualified disaster that you were subject to in either 2023 or 2024.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, is joining us. We're covering several parts of the One Big Beautiful Bill Act that he has listed on this latest edition of the Rural Practice Digest that he has posted on his Substack, Roger's Substack, that it's currently what we're talking about. Now, another part of the One Big Beautiful Bill Act is Section 70202, or like you said a couple of weeks ago, 70,202 of H.R. 1. This concerns overtime pay.
Yeah, this is an interesting provision. It's a tax-related provision, and some farmers, you and I haven't talked about this one, but some farmers may have been hearing something about, well, I can get a credit, or I can get a tax deduction, not a credit, a tax deduction if I get paid overtime. Well, yeah, but not so fast as applied to agriculture. What this is in the One Big Beautiful Bill Act is that you get a deduction for qualified overtime pay. And the whole thing hinges on what the word qualified means. Now, I'll come back to that in just a second. It's capped at $12,500 for the tax year for a single filer, the deduction is, and double that for somebody that files a married filing joint return. And it's got phase outs on it. So as your modified adjusted gross income exceeds $150,000 on a single return or $300,000 on a married filing joint return, then the deduction phases out. Okay. That's all fine. Most people won't hit the phase out, but the provision defines qualified overtime compensation, and this is the key, as compensation paid to an individual required under Section 7 of the Fair Labor Standards Act of 1938 that is in excess of the regular rate. And I can see and hear people's eyes rolling to the back of their heads listening to that. Like, well, okay, well, what's the big deal there? Well, that's a big deal when we apply that to agriculture, because under the Fair Labor Standards Act, and this is why I say that agricultural law is often law by the exception. This is one of those exceptions, and it's going to come back to bite you this time, because agriculture is often exempt from the requirement to pay overtime to employees. So under the Fair Labor Standards Act in 1938, and this was the Roosevelt administration, FDR, they exempted agricultural employees from overtime requirements. And so the employers are not legally required to pay time and a half after 40 hours a week under federal law. Since the deduction applies only to Fair Labor Standard Act required overtime, fair labor that isn't Fair Labor Standard Act mandated does not qualify for the deduction. So an ag employee won't qualify for the overtime deduction because they're exempt from the overtime rules. So the overtime is not required by Section 7, which is how they tied this in. I don't know if that was intentional or they just didn't realize that, hey, ag is exempt and you're going to have different language in here if you want to include agricultural employees. But you're out. You're not going to qualify. And even if an employer voluntarily pays overtime, say due to state law or by contract, that overtime is not qualifying because of the definition here that ties it to the Fair Labor Standards Act of 1938.
Yeah, and you mentioned state law, and that's got to be, or throwing in a little complication there, depending on what state you're in and how they would tax that too.
Yeah, if a farm worker, because we got a couple of different states that are out there. Washington has done stuff with overtime wages. California does. So let's say we've got a farm worker that earns overtime due to California's state overtime laws, or the state of Washington, their overtime laws, or by an employer contract. That pay is still not qualified overtime under the Fair Labor Standards Act because it doesn't meet the One Big Beautiful Bill Act definition, so it's not eligible for the federal deduction.
In other words, contact your tax person to make sure they are well aware of this situation as well, because that's one, like you said, they can come back to bite you, and that's not going to be a pretty bite.
Yeah, and obviously we'll cover this at the K-State Tax Schools this fall, and I'm covering it at all my seminars right now, just to make sure the tax preparers are up on this, because if you're not aware, you might have a client that says, well, I got overtime and it's this many hours. They say, okay, you're qualified for deduction. Not if it's agricultural labor. This may be one thing that we often, Greg, have technical correction bills when we have major pieces of legislation that have tax provisions in them. I don't know if they'll do a technical correction on this. I don't know if this was intentional or if this is just one of these places where, ag is different and you're going to have a different rule if you want the same result for ag employees. I don't have an answer to that. It's just, bottom line is, if you're an ag employee and you get overtime, you're not going to get a deduction.
All right, there is one case we want to cover. As a matter of fact, this was a Kansas case as well. This has to do with real property, or in this case, specifically prescriptive easement.
Yeah, this was out in western Kansas, and what happened was you have an unincorporated town that had a bunch of parcels in it, and there were, I think, 9 or 10 of these parcels in this town, or it was a tract of land, I should say, and it was parceled out in 1937 as a result of a foreclosure sale. And one of these tracts was landlocked, and so every single owner since 1937 was crossing another tract to get access to theirs. And finally, you had one person a few years ago of this other tract that put up a fence and blocked that access. Well, the point is, you can't do that. That's a prescriptive easement. That was pretty easy for the Kansas Court of Appeals to sort that out. Now, the frustrating thing to me is, why did this get to the Kansas Court of Appeals? This should have easily been resolved either through mediation or settlement or at the trial court level. But somebody decided they wanted to push it, and it's one of those, the court gets this, yeah, that's a slam dunk. You don't have an argument there. That's an easement by prescription. That's a well-established route. For a long period of time, you can't put a fence up and block it off. And but Greg, I get that question all the time, and it's a pretty standard answer. How long have you been using that? What's been the understanding here? And the answer in that instance is, well, once it's been there long enough and that continued use occurs, you can't block it. That's an easement. The court will imply an easement by prescription.
And I'm sure throughout the years, you have seen that or experienced that or been in court with that many times too.
Over and over and over. I can't tell you how often that happens.
All right, Roger, we're almost out of time, but again, if people want to read this, obviously they can go to your Substack.
Yeah, that's McEowen Ag Law and Tax.substack.com. It's all one word.
And then obviously you keep up to date on many issues through your blog as well.
Yep. In fact, there's one that we'll probably talk about in a couple of weeks involving crop dusting.
All right.
That I just put up.
Oh, go ahead. I'm sorry. Oh, okay. Yeah,
I just put that one up.
Okay, sounds good. Well, Roger, as always, I appreciate it. Enjoy the time in Pennsylvania. We'll talk to you here in a couple of weeks.
Thank you, Greg.
That is Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.